The scheduled time and we have a quorum. Members must turn on the Zoom feature and to show your face while speaking. The microphone will only be turned on under my instruction. You must use the 3 different background colors. We are now going to meet with the administration. Please refer to the paper given to us by the administration. We have CB bracket for 102/2021 after the meeting last time. We have already put up a consultation on the subcommittee to study the emergency date of election, 6-term chief executive regulation related issues, and as of the deadline, the secretariat has not received any comments. In the last meeting, we have discussed the paper, and we have not started our clause-by-clause scrutiny. Do any members still have questions in relation to the paper? Other than Dr. Teck Chi Yoon, anyone else? All right, Dr. Teck, please. Thank you, Chairman. Well, we are still very concerned with the pandemic, and we still do not have a clear timetable on the arrangements for the universal compulsory testing. We are postponing the election of the chief executive because of the pandemic, and under the basic law, we should have the new chief executive on board by July 1st of this year. The pandemic seems to be surging, and in the next 2 to 3 months, the HKSAR government will need to prevent and control the epidemic and also to work on the CE election. These are 2 very important issues. How can the government balance these 2 problems? During the election of the CE, would there be any impact on the work in controlling the pandemic? Some of our major officials may run for the election, including the current CE herself. Would that actually have an impact on pandemic work? Secondly, we are now 100% focused on the pandemic. Would the arrangements of the election of the CE actually affect the work of fighting the pandemic? I hope that the administration can give us a very confident answer. Well, these questions have been repeated again and again, and we have encountered many hypothetical questions. I'm not sure whether the administration can answer this question. And however, I do not want members to keep on asking hypothetical questions. We do not know who is going to run for the CE. We are just going to work on postponing the election at this moment. Who's going to take this question? Yes. Well, let me try to answer this hypothetical question once again. Of course, the government is now putting its main focus on the prevention and controlling of the pandemic. We do have enough manpower in arranging and organizing the election of the chief executive. And we have made very good arrangements. Other than those working in the election of the CE, we still need to consider whether we'll be able to reach out to the voters and also to members of the public. We are still working towards the objective of holding the CE election on May 8th. Dr. Dick, do you have any follow-up? Yes. So is May 8th the only option We've answered this question many times. Mr. Tang, can you please take this question again? Yes, this is the only option at this moment. Thank you. All right. No other members have questions or comments, so let us move on to the clause by clause scrutiny. We are now going to go through this regulation. So this is notice LN22 and also included in our papers. So please refer to LN22. I now invite Ms. Carmen Kong, Principal Assistant Secretary of Constitutional and Mainland Affairs, to take us through the clauses. So please pause after each clause so that we'll know if members have any questions. And then we will discuss that before we move on to the next clause. I refer you to the annex of the paper. So on page 1, members will see part 1. Part 1 is on the effective date, listing out that this will be in effect from 24th of February. Any questions from members? No? All right, let us continue. Thank you. So second is on interpretation. So we have made definitions on the regulations. The first one is on discontinuation date, on discontinued election, showing the poll at which is scheduled to be held on the original date. All right, no questions. I'm sorry. I cannot see very clearly. Mr. Tony Zhe, did you raise your hand? Chairman, on the interpretation part, I have a question. May 8th is to be the new election date, and the PS said that it's the only option. Why is there flexibility in the interpretation? Why couldn't we leave some sort of flexibility that in case we're not able to carry out the election on May 8th and to put out another option? Well, we haven't yet moved to that part yet. We are now just in part 1 on the interpretation. Oh, I'm sorry. I'm sorry, Chairman. Ms. Kong is now pausing after each part. Well, how about you just go through the interpretation in one go so that members could be more focused in their questions. Please continue. Thank you. Well, let me first handle the interpretations, and then members can ask questions in relation to the interpretations. Also, we have defined the discontinued election. And the next one is discontinuation date, which means February 24th of this year. So the original chief executive election day has been discontinued since February 24th. Next is the election of the CE. Because we need to make an election to fill the vacancy in the office of the CE. Next is the original date, which means March 27th of this year. So the original date of voting for the CE was March 27th. And here you also see interpretations of CAP 541J, CAP 554, and CAP 569, which are the long titles of the original regulation. Next is postponed election, which means the CE election, the poll which is to be held on May 8th. Members can now move on to page 2. You would still see interpretations. The next definition is returning officer, which has the meaning given by section 2(1) of CAP 569. Next, electoral matter. A and B. A means an act that is done or purportedly done under the electoral law, and B includes an election-related document as defined by section 84(6) of CAP 541J. Next interpretation is electoral law, including bracket A and B. Electoral law under this regulation means any law in force providing for an election to return a candidate for appointment by the Central People's Government to fill the vacancy in the office of the Chief Executive, and B, including any guidelines issued under Section 6(1) of the Electoral Affairs Commission Ordinance CAP 541. Next, election expenses, including bracket A and B, meaning that in relation to the discontinued election has the meaning given by section 2(1) of CAP 554 as read together with section 7(2) and B in relation to the postponed election, which refers to May 8th, has the meaning given by section 2(1) of CAP 554.
The next interpretation is the definition of the Chief Electoral Officer. It's also in accordance to CAP 541, Section 2(1), and the definitions contained therein. And finally, the definition of function. It includes a power and a duty. So, Chairman, with regards to the interpretation part, I have covered all of the various aspects of the interpretation part. I think just now, the question posed by Councillor Tse, does that involve the last line of the first line, the postponed election? Section 5(1), where it must be set on the 8th of May. So I think could it be changed to say held on 8th of May or afterwards? Like, would that be a more flexible thing? Have I misunderstood you? Chairman, you have understood me correctly, but I want to pinpoint it a little bit further. As Chairman, you have pointed out, it's the postponed election bit. With regard, I want to ask about the flexibility here. Have you thought about this? For example, you might change it to the discontinued postponed election. I think if there would be a further change of date, you could leave a little bit of room for yourself. So, Roy Tang, I'll let you answer that. So, thank you, Chairman. When we are thinking about conducting an election, we must also think about the fairness of that election. And one of the core requirements, of course, is certainty. So if an election lacks certainty, the candidate and its supporters and his competitor cannot plan properly. So we must give society a clear message that we think the 8th of May is the appropriate day. So, of course, what would happen afterwards, we don't know. But if we leave too much room for speculation, then there would be unnecessary speculation in society. So that's why we decided against leaving any flexibility and room for further adjustments. Any follow-up? Thank you, Chairman. Well, I'd like to ask, to date, the government have not considered to leave any flexibility within the law. I'm not trying to say that the date 8th of May will change. It's mainly that the the date is fixed, it's 8th of May, but it seems that the provisions of the law does not allow for any flexibility, except if the chairman of the EAC may use his existing powers to postpone the election. Barring that, I think the date is fixed, right? Is that the principle that the government is adhering to? Yes, your understanding is correct. For now, the government is following this principle when it comes to handling matters pertaining to the CE election. So I think there are two colleagues who have raised their hands, Carmen Kwan Wyman and Engineer Lo Wai Kwok. Carmen Kwan, please. Thank you, Chairman. The question that you posed and the question posed by Councillor Tse, it's about the interpretation, and that's my concern as well. I heard that Mr. Roy Tang said that the date is clearly 8th of May. That shows how clear the government is being and how determined the government is, and I understand that. So, but due to the pandemic, could we think about leaving some room for ourselves, or some flexibility? So right now, where we're talking about 241M, 241M is a completely new provision. It's a sub-law under the Article 2, Section 241. We are not amending 569. We are not amending the. We are not amending the existing electoral laws pertaining to the CE election, because the emergency laws allows us to have more room. That would give us more flexibility, because 241 gives us the power to prevail over existing laws. So I want to confirm whether or not that is why you use the 241M in order to make such an amendment. It's because that this law prevails over other laws. So since that's the case, you said that the election will be postponed to 8th of May. Could you say that in accordance with 24M, we will postpone the date to a further date? So if and when you want to further postpone a date, you don't have to come back and to issue a 241O, right? Because we know that 241N has already used for other measures, like exempting other exemptions pertaining to other matters. Like, what if we have to postpone the election again? What will we do that? So we know that last time the Electoral Affairs Commission already has the power to postpone the elections by 14 days due to public health concerns. So right now, that's my second question. We set the 241M as 8th of May, and that does not conflict with the flexibility we have under other laws, right? If the EAC chairman decides to postpone the election by 14 days due to public health concerns, he would still have that power, right? Do we need a saving provision under 241M? I think the DOJ could also offer some advice in this regard. So how should we do this? If we have to postpone the election, do we need 241O or what? Mr. Roy Tang, please. Firstly, let me answer the second part first. Regarding assuming, right, after we have passed this, after the LegCo have approved this law and voted on this law, this election date will be a new election date. And under the Section 21 of the CE election laws, if the Electoral Affairs Commission decide to postpone the election by 14 days for the sake of public interest or public health, this is applicable. This law is still applicable. I'm not saying that this will happen or this will not happen. I'm just saying this is the hypothetical. But our view is that after all, if you want to change the date of CE election, that's a very important thing to do. It's a serious matter. And it's not just about the Hong Kong SAR government alone. We also have to consult the Central People's Government on their opinions on this matter. As we understand that the central government will appoint the CE after she is elected. So the process must be a dignified and somber one. So what will happen if we must amend this date? It seems that we have to make use of the emergency laws again. Please understand, this process itself, in terms of constitutional law and law, it has empowered the chief executive in council to make that decision after considering the actual circumstances, and then we have to go back to LegCo and go through what we're going through right now. So the legislature would have the opportunity to go through a reasonable process and offer proper scrutiny. It wouldn't be the case that the administrative branch, they could take an extra step just because they want to do so. And indirectly, that's my view, that would deny the legislature the opportunity to scrutinize this law. I think that would be inappropriate. So the clarity of the law and the process itself are both important. So Mr. Roy Tang means that if it's really 8th of May, if we're not talking about the 14-day postponement due to public health, if there are further need for postponement, we would use 241 again, and then to change the bylaw and to change the date again. Is that the case? Mr. Roy Tang. Chairman, if the practical circumstances then does adhere to the requirements stipulated by emergency laws, then of course we would consider using the same emergency regulations to amend that law. This is a hypothetical situation, but that's the understanding from a legal point of view. Lelwin Mui, do you have anything to add? Thank you, Chairman. Just now, the response from the Permanent Undersecretary on Councillor Khan's question, I really agree with that legal point of view. I have nothing to add for the moment. Any follow-up, Councillor Khan? In other words, the response from the DOJ is that they confirm that this is indeed how the process should go. So we would once again use a 241 to make another extra law. So thank you for your follow-up question, Councillor Khan. Just as what Mr. Roy Tang has explained, if and when the 8th of May date cannot go smoothly, we cannot actually host the election then. And just as what Councillor Khan has pointed out, the EAC has the power to postpone the election by 14 days. If that law does not can't handle this issue neither, then right now our view is that we agree with Mr. Roy Tang that we have to use that law to handle this matter. So thank you, Chairman. My question, it seems that has been. Well, we can see the answer to that question based on my question. It seems to have already answered in the previous answer, but I want to hear it clearly. In other words, even though now we say that it's set in stone, it will be 8th of May, but after all, we would still have one more measure we can take. That if the postponement is no more than 14 days, they don't have to go back to the Legislative Council to go through the process. But if we need a further extension in the existing law, there will be no room for avoiding going through this process, right? We have to go through the process. But in the previous session, everybody understands. Even if we have to postpone the 8th of May election date, there's very, very little room for postponement. Is my understanding correct? Thank you. Councillor Loh's understanding is correct, but it must be grounded in the fact that the postponement of 14 days is in accordance with the various situations applicable under current electoral law, and if and when the 541J provisions are applicable, only then could the EAC postpone the date of the election. You can't just postpone however you like. No further follow-up questions. Next question is from Councillor Priscilla Leung. Thank you, Chairman. I'd like to ask a question. And that's just my view, because in the section 15, it says that the date starts with 3rd of April. I think. Given the current pandemic situation, like the April date is might not be an agreeable one to commence the entire process. So of course, if it works out, that would be great. We could fix everything by 22nd of May. But what if we have to postpone again? And that would impact the 30th of June handover period. Do you have to look into the legal issues therein? That's what I want to remind everyone with. Like, is it something that the Article 241, the Section 241 law emergency regulations can solve, like at the Hong Kong level? Like, I'm just trying to remind you, we need a plan B for everything, right? I really understand why you have to clearly state that it will be the 8th of May. But as we know, that if the period start on 3rd of April, that's perhaps is too optimistic. We must face the facts. So when it comes to matters pertaining to the law, I think you should conduct your research as soon as possible. Like, is this an eventuality that could be solved by the emergency regulations alone, or does this involve the basic law? Thank you. So, Councillor Priscilla Leung, we have been going back and forth, but now we are in examination of individual positions, and now you suddenly raise Section 15, could it be done? Could it not be done? What happened if the postponement of 14 days happen? Like, if you do that in the current phase of the talks, I think you're making it more difficult for us. That's okay, Chairman. I just want to, please do not interrupt me. Now I'm asking Mr. Roy Tang to answer your question again. This question has been asked and answered many times. Mr. Roy Tang, please. So anything which goes beyond 30th of June is not something that the Hong Kong SAR government can handle itself. So even if we have any considerations, we must consult the opinion from the Central People's Government. And of course, we think that the central government would have a very clear view on this matter, but this is just a hypothetical issue. Any follow-up, Councillor Leung? So do they have a plan B? If they have one, that's great. I just want to remind them because I'm satisfied with his answer. So any other councillors, any other colleagues have any questions? We have gone through the interpretation. We are up to page 2. If there are no further questions, Ms. Kong, please continue.
Thank you. We now move on to page 3, which is part 2. Change of date of Chief Executive Election. Section 3. Notices in respect of discontinued election revolt. So we have bracket A and bracket B under this section. Two notices are revoked. 3A, the notice of polling date of Chief Executive Election, which was published. And B, the notice of nomination for Chief Executive Election, which was published. So section 3 revoked these 2 gazetted notices. Thank you. No questions from members. Let us move on to the next section. Section 4, discontinued election ends and related electoral matters cease to have effect. Bracket 1, the discontinued election comes to an end at the beginning of the discontinuation date. So under the interpretation, the discontinued election is on February 24th. So that means that the original election has been discontinued. Please continue. Bracket 2. Except for the purposes of the matters provided in Part 3, all electoral matters in relation to the discontinued election that took place or came into being before the discontinuation date, including the notices referred to in Section 3, cease to have effect as from the beginning of that date. Please continue. Bracket 3. To ensure that there is no doubt and without limiting subsections, bracket 1 and 2, A refers to section 11 of Cap 569, not applying to the discontinued election. And B, except for the purposes of the matters provided in Part 3 on and before the discontinuation date, and electoral officer and the CERC established under Section 9A are not required to perform any function. And C, the electoral matters referred to in subsection 2. So that means that after the discontinued election, all other matters would not be in effect. So B refers to the Candidate Eligibility Review Committee and electoral officers and the CRC are not required to perform any function provided in any electoral law in relation to the discontinued election. C, please. C, on electoral matters referred to in subsection 2, not having an effect in relation to the postponed election. So that means that any electoral matters will not have effect on the May 8th election. Any questions from members? No? All right, please continue. Thank you. Members, please refer to page 4 of the regulation, which is section 5 of part 2, date of poll and nomination period at an application of electoral law to postponed election. 5(1). Section 10(1) of Cap 569 does not apply to the postponed election because the original section 10(1) is in relation to the original date. So this now refers to a new election to be held on May 8th instead of the original date. Any questions? No, please continue. 5(2). To take May 8th, the date of election, as the date fixed for the poll at that election under section 10(1) of Cap 569. Any questions? Please continue, Ms. Kong. Bracket 3 on section 15(1) of Cap 569 not being applied to the postponed election. And the nomination period at that election is the period from April 3rd, 2022 to April 16th of 2022, both dates inclusive. Any questions? Please continue. Bracket 4. This is in relation to subsection 3, which is on the nomination period. The Chief Electoral Officer must publish in the Gazette a notice which states the matters referred to in section 3(b), C, and D of Cap 541J, which is the publishing in the Gazette on matters on date of nomination and the nomination period and deadlines. Any questions? Please continue. 4(b) on the postponed election. April 3rd to April 16th, both dates inclusive, is to be taken as the nomination period fixed under section 15 of Cap 569. We have now scrutinized part 2, section 5. Any questions? It seems that members have not had any questions so far. If there are no questions, we now move on to part 3. 3 is on matters related or consequential to change of date of chief executive election. Section 6, matters arising from change of date of CE election. Subsection 1, on and after the discontinuation date, there are bracket A, B, and C referring to work and functions that may continue. Bracket A, the returning officer or the chief electoral officer must continue to perform their functions under sections 14 bracket 9 and 87 bracket 7 and 8 of Cap 541J, mainly on nominees submitting applications to the returning officer on electoral expenses used. The returning officer or the chief electoral officer, when they receive these documents, will continue to make these public. If there are no questions, please continue. In bracket B, the returning officer must send any document referred to in section 57 F, G, H, I, or J of Cap 541J in relation to the discontinued election to the chief electoral officer. And the chief electoral officer must deal with the document in accordance with section 59 of Cap 541J, that is about a 6-month period beginning with a discontinuation date. So these must be kept and safeguarded by the chief electoral officer for 6 months. C, a candidate's functions, which is as defined by section 2 bracket 1 of Cap 541J, must continue to comply with section 87 bracket 2 bracket B of Cap 541J in relation to the discontinued election. And so the candidate must continue to, in accordance with the law, to submit electoral expenses documents. Please continue. 6 subsection 2 on election expenses. Any election expenses incurred at or in connection with the discontinued election by or on behalf of a person are not to be regarded as election expenses incurred by or on behalf of the person at or in connection with the postponed election. Any questions? Please wait. I cannot see. Two members have raised their hands, Mr. Andrew Lam and Dr. Priscilla Leung. Am I correct? Mr. Andrew Lam. Thank you. I'd like to ask about the electoral expenses. So when a candidate cannot or is not a valid candidate, then that person will not need to submit the expenses in relation to the election, right? That is not correct. The candidate means, or any candidate means, a person who has at any time made a public announcement that he or she is running in the election would be considered as a candidate. And even if the date of election has not begun, the election return must still be lodged. Some persons at other elections had their nominations revoked, and those people would still need to lodge an election return. So that is done in accordance with the law. Then that is very clear. Mr. Lam, any follow-up? No. All right. Dr. Priscilla Leung. Thank you. the public has heard from persons who have made public announcements to run for the CE. But now we are postponing the election, and that is a bit different from those who have been disqualified. You have to make a public announcement that you're running for the election. So do you have to remind these persons to lodge an election return? I'm saying that there is more than one, not everyone will log in and listen into our bills committee discussion. Would you let them know that they need to lodge such a return, because it is very rare that a CE election has to be postponed? So I'm not sure whether we should do that. I'm not sure whether any returning officer would tell me or notify me what should be done after I start running for an election. But I know this is a rare occurrence. PS, how about you give us an answer? Dr. Leung's question is a very reasonable concern. On the date of discontinued election, so on February 24th, we have notified those who are running for CE, and we sent them a letter listing out what they need to do and that they need to lodge an election return on a specified date. And we have also listed out the forms in which they need to use. We also notified them that the May 8th election would see a recounting of the election expenses. Well, yes, it is a very good idea, because we do not want to see any candidates fall into this trap. So this is a very good idea to notify them.
Next comment, Kanwai Man. Thank you, Chairman. So first question. Just now, Ms. Kong, when she's going through the various provisions, it says that in Section 5 and Section 6, it says the returning of the chief electoral officer must do something or another. Like, what internal controls are there to make sure that they are doing what they're doing? And firstly, there are no punishments stipulated, and secondly, how could the public know that they have done what they should be doing? And we have not covered Section 6 parentheses 3 yet. So, Mr. Roy Tang? Chairman, so under Section 6, it stipulates under what situations, even if in a normal election, a returning officer or chief electoral officer would have those duties. What situation does it cover? So, for example, the candidates, they have already submitted their campaign ads, and the platform must keep on going for a while. For example, the documents of notification that you receive, that must be handled as well. So there must be a platform online so that the public can access the information submitted to the chief electoral officer. So the public can still access this information on the platform. So if the public wishes to know what happened, what did the electoral officers do, they could click onto the electoral website and click onto the CE election website. And yesterday I checked myself, I still see it. You can see all these campaign ads, you can see all the videos they shot, you can still find them. So this shows that the public is well aware that these things are still being done. And as for after the campaign has started, how would the public know? They set up an office, and we are waiting for the candidates and the people who have once declared their intention to run. They would submit their application, and the letter that I have mentioned just now, the chief electoral officer and the office have sent those letters to the few candidates who have once declared their interest to run. So as a civil servant, whatever we do is subject to public scrutiny, naturally. Any follow-up? No follow-up, ma'am. So Councillor Priscilla Leung, second round of questions. Thank you. I'd like to follow up on this. So everybody who has stood for election knows that after we get elected or after the campaign period, there are a lot of advertisements like non-government ads. It will not be removed, like on minibuses, on whatever, it would continue to exist. So you have clearly said just now that this would not count towards the next round of electoral expenses. But a lot of these people who help people do ads, they are private enterprises. They would not remove the existing ads. Does that have any impact, or should it be proportional? How would the calculations be done? Because the candidate originally they want to join the election on time. I said that I don't want to participate in the election anymore, and I've asked the person to remove the ads. The person did not remove the ad, so the ad continued to exist till the 8th of May. So how does that count? What would that do? So this is about a policy discussion. This is not a clause-by-clause discussion. We have already covered that topic. So Mr. Roy Tang, why don't you answer that quickly? So it depends on the intent of the candidate. If we receive any complaints, the electoral office will be responsible for investigating and collecting evidence. If we clearly see that the candidate does intend to do so, or they have not taken reasonable steps to remove such ad materials, then in the end we would receive a complaint. And once we receive a complaint, as we know, CAP 554 is under the purview of the ICAC, and we will collect evidence then. If we can prove that they have the intent to use the ad campaign material without declaring, this is actually a very dangerous activity for him, because apart from the various punishments under the 554, if you violate CAP 554, it might constitute a reason for cancelling your qualifications to stand as a candidate for 5 years to come. So in other words, he or she must have actively say or write a letter perhaps saying that he or she wants the ad to be removed. And after that, he or she will be absolved from blame, right? You just have to submit evidence. We are discussing a clause-by-clause issue right now. I hope you understand. I understand, Chairman. I'm done with my question. I do not hope that we are trying to revisit these issues and rehash these issues at this moment. Everybody understands what's happening. So let us continue, Ms. Kong, with Section 6, parentheses 3. So Section 6, parentheses 3, anything done by a person before the discontinuation date is not to be regarded as a public declaration by the person of the person's intention to stand as a candidate at the postponed election. Simply put, the declarations made before the discontinuation date does not mean that he or she is intending to participate in the postponed elections dated on the 8th of May. So, Carmen Can, did you have a question about Section 6, parentheses 3? Yes. Thank you, Chairman. So when we are scrutinizing Section 6, parentheses 3, I'd like to say that this rule is not problematic, it's clear. And how could we inform the legal requirements about these to the people? Like how would people know that there's such a law, and how could the law be transparent? So, Chairman, we think that after this bill passes, the government, when we publish the new law on our gazettes, we would publish all these relevant provisions. If and when necessary, we would conduct a public campaign, promotional campaign as well. We would do that. Thank you, Chairman. Are there any further questions? If not, Section 7. Ms. Khan, please. Ms. Kong, please. Hello, Chairman. With regards to Section 7, application of CAP 554 to discontinued election. CAP 554 is the electoral laws corruption regulation. So parentheses 1, for the purposes of Section 4, parentheses 1 of CAP 554, the discontinued election is an election to which CAP 554 applies. So it just includes this election under CAP 554. So are there any further questions? If not, please continue. Parentheses 2. CAP 554 applies to the discontinued election with the following modifications. Under parentheses A, in paragraph B of the definition of candidate in section 2, parentheses 1 of CAP 554, with regards to the discontinued election, the reference any time before the close of nominations for an election is taken to be a reference to any time before 24th of February, year 2022. Please continue. B. In section 2, parentheses 1 of CAP 554, the following definition is taken to be substituted for the definition of election period. Election period means the period beginning with 20th of February, year 2022, and ending with 23rd February, year 2022. Because the election period was originally intended to, the nomination period was originally intended to start the 20th of February, and our new law takes effect in 24th of February. So the election period, there's a definition which about how the election period is calculated and defined. So we are just clarifying that the 23rd of February, year 2022, will be the period ending, will be the end of the election period. Continue, please. Under section 7, parentheses C, the following provision is taken to be substituted for section 37, parentheses 1A of CAP 554. So the section 37, parentheses 1A, it says the candidate must ensure that the election return is lodged before the expiry of the period of 60 days beginning with 24th of February, year 2022. And this declaration refers to the declaration pertaining to the discontinued election as defined by Section 2 of the Emergency Date of Election 6th Term Chief Executive Regulation. Are there any further questions? We have gone through Section 7. We have a question. Is it Councillor Lam? I'm sorry, I couldn't really see your name. Councillor Lam, please. I'm sorry, Chairman, I would like to ask, under 7B, when it refers to the election period from February 20th to February 23rd. So the way it's written here, compared with section 4, no, sorry, compared with section 5, parentheses 3, section 5.3 and 5.4b, when the dates were mentioned there, it says parentheses, both dates inclusive. But here, it does not say the words both dates inclusive. I just want to know, why is there a different treatment here? Is this legally significant? Madam Kong, thank you, Chairman. This is a convention in drafting. I want to ask Mr. Mui to explain this. Mr. Mui, please. Thank you, Chairman. I'd like to also thank Councillor Lam for his question. So this provision, 7 parentheses 2b, the wording there, as we understand, is correct because it says a period, right? So just as what Councillor has pointed out, in 5 parentheses 3, it says parentheses, both dates inclusive. The expression is different. So the expression in 7.2b is quite clear. Perhaps I could ask the draftsman, Mr. Chan, to supplement. So, Mr. Chan. Thank you, Chairman. Thank you for your question, Councillor Lam. So actually, both ways of writing this is appropriate, legally speaking, is effective. The main reason is that in theory, when we're talking about Section 7, we are trying to replace the CAP 554 and to replace the clauses contained therein. So we have just followed the customary practice in drafting the legislation. And previously in Section 5 and whatever those new laws, and in that section, we do not have to take into consideration the drafting tradition in other pieces of legislation. So where it pertains to CAP 554, we follow what happens in 554, but both ways of writing it is clear and it includes, and we hope that everything is covered. Any follow-up questions, Councillor Lam? No questions. Thank you, Chairman. So, okay, if there are no further questions, we will now move on to, we have covered even Section 7 on Part 3, and next we are up to the explanatory notes. Ms. Kong, please. Thank you, Chairman. So on, we are now up to page 7, and it says, the purpose of this regulation are to A, revoke certain notices, and the subcommittee members have already scrutinized under Section 3. There are 2 notices being revoked with regards to the nomination period and the election date. Please continue. And B, it provides that the discontinued election comes to an end at the beginning of 24th of February 2022. In other words, the election has been discontinued starting 24th of February. And just now, during the subcommittee's meeting, we have already said that certain matters pertaining to the election is no longer takes effect. So originally in Section 4, we have already included those matters. Okay, please continue.
Bracket C. To provide that the poll of the election to elect the 6th term CE on May 8th instead, and that the nomination period of that election is the period from April 3rd to April 16th. Please continue. And lastly, to provide for related or consequential matters. So this relates to Section 6 and 7 on some of the functions that need to be continued by the returning officer or by the chief electoral officer. Any questions from members on the explanatory note? If there are no questions, we basically have gone through all the clauses. I'll ask members again if you have any other questions. If there are no other questions, then our usual practice is that after we complete the scrutiny work, then the legal team would work on the English version of the regulation. I can now let members know. So we are going to submit it to Council on March 16th. And the amendment would be April 6th. The deadline for giving notice of amendment would be March 29th. And the date of reporting to the House Committee would be March 25th of this year, because the regulation will be introduced into LegCo on March 16th. Members, are you all clear on that? I will report deliberations of this subcommittee to the House Committee on March 25th. AOB. We do not have AOB. The meeting is now closed. I would like to thank everyone for attending the meeting. Thank you.